Good morning. I either need a platform in front of this or to lower this, but I need to get taller. I'd like to welcome all of you. Can you hear me? Okay. I'd like to welcome you today. I'm honored to once again be chairing the 6-minute Commercial Leasing Lawyer Conference. I know that you'll find this morning's program useful and enlightening, just as the last 1997 6-minute commercial leasing lawyer program was. We had rave reviews for that program, and but judging by this morning's attendance, I can see that everybody shared those, my view and others' views, and filling out the reviews that this is an excellent program. In fact, I personally think that this is one of the best, if not the best program, because the 6-minute format gives us the opportunity to hear from a lot of experts, a lot of sophisticated topics in the landlord and tenant area, and 6 minutes doesn't give anybody the opportunity for one's mind to wander if you're off onto the next. So the drill this morning is that I will introduce each speaker, and they will speak for 6 minutes. If there's a chance and there's time, I would like to have a couple of questions after each speaker. There is this, we call it an egg timer. I guess it should be a lemon timer, which will go off and ding, ding, ding at the end of the 6-minute period. Unfortunately, time doesn't permit me to fully introduce my distinguished speakers, and so their CVs are at the back of their materials, and I direct your attention to that. I'm grateful to the commitment and assistance that I received from my organizing committee, and that was Bram, Costin, Ron Goldenberg, Bob McDonald, and Monty Warsh. And they did a great job in putting this program together once again. We're delighted to have today's seasoned commercial leasing experts as our speakers. I think that these are interesting times in which we are living in the real estate industry. I think they're cautiously good times. And I'd like to also ask you to please, after this morning's program, there is an evaluation sheet in the beginning of your materials. If you could fill that out and leave it at the, just outside here, there's a box. That would be great. That's very helpful for the Law Society. So without further ado, I'd like to introduce my first speaker. Just hit me that I forgot to introduce myself, but for those of you who don't know me, I'm Ariella Rohringer, and I'm with Goodman & Carr. And so moving forward, the first speaker we have is Harvey Haber of Goldman, Sloan, Nash & Haber. And Harvey is going to address how recent Ontario legislation detrimentally impacts the landlord's rights of distress and other practical problems in commercial leasing.
Morning, ladies and gentlemen. If you're acting for a landlord or the landlord's agent, a bailiff, this new legislation scares the heck out of me. Believe it or not, the Ontario government has revised the Retail Sales Tax Act involving a landlord's right to distraint. What is distraint? It's a right of a landlord to seize a tenant's goods, chattels, and inventory for outstanding rent. I'd like you to take a look at tab 17. It's page 164 of the Retail Sales Tax Act. It's under my own tab with number 1. Look at the top of the page. You'll see a subsection 5. I'm going to take a little piece of that out, read it with you. Every person who, as a secured or unsecured creditor or agent of the creditor, going to jump down a little bit, takes control or possession of the property of any vendor shall, here's the key word, before distributing such property or the proceeds from the realization thereof under that person's control, obtain from the minister a certificate that the amount deemed by subsection 1 to be held in trust, including any interest and penalties payable by the vendor, has been paid, or that security acceptable to the minister has been given. This involves, of course, outstanding PST. All right, now look at subsection 6. any person described in subsection 5, that would include a landlord or a bailiff, who distributes any property described in that subsection or the proceeds of the realization thereof, and are you ready? Without having obtained the certificate required by that subsection, and here's the key, is personally liable to Her Majesty in right of Ontario for an amount equal to the amount deemed by subsection 1 to be held in trust, including any interest and penalties payable by the vendor. Okay, so that means that the landlord solicitor gets a call and says, as is usual, from his client, go in and seize the tenant's goods, chattels, and inventory for outstanding rent. Now, normally what would happen is the landlord would call his esteemed bailiff, one that he uses, a reputable, acknowledged, experienced bailiff, and say, go in and seize the tenant's goods. Okay, but this section says, hey, if you don't get a PST clearance from the Ministry of Finance before you render that distress, you or your bailiff is personally liable. Okay? Not only personally liable, but personally liable for all the outstanding retail sales tax, penalties, and interest going back to January 1, 1998. All right? Now let's take a typical example. The client says to the landlord solicitor, I want you to go in and seize, he owes me 2 months' rent, $2,500. Okay? It's a small place. Right? What happens is, without knowledge of this particular section, you go in and seize, and then the ministry advises you that, hey, this fellow owed PST of $12,000. You've gone in to seize for $2,500, $2,000, $1,500, whatever you've gone in for, and suddenly you're hit personally, okay, for all of the outstanding PST since January 1, 1998. Now, I recently lectured to the Bailiffs Association, scared the heck out of them as well as me. They then went to the Ministry of Finance, and I want to refer you to tab 19. Wait till you hear this one. This is the letter from the Ministry of Finance. Okay, at our meeting, this is the second paragraph. This is to the Bailiffs Association. You raised a number of concerns on behalf of your membership. These concerns included your ability to obtain information from the Ministry of Finance files prior to your clients making a decision on which procedure to follow, the fees and expenses being payable in priority to the minister's deemed trust claim, and the limitation of your member's liability if the seized goods are not worth the amount of the ministry's deemed trust claim. Okay, listen to this. We have researched the confidentiality issue and find that Section 10(1) of the Financial Administration Act, you ready, allows the ministry to release taxpayer information to a bailiff already in possession of a tax debtor's assets. Now here's the killer. However, disclosure of taxpayer information to allow a landlord to make a decision to distrain or not would not be permissible. Is that good? That's great. You ready? The best procedure for bailiffs to follow, if they require information on the tax arrears of a debtor, would be to make a PPSA and execution search. This information may be sufficient to decide on a course of action, and in the event that the ministry has registered a PPSA lien, which they'll do, of course, after you call them, or writ quite some time ago, and therefore the amount owing would not be current, or if the ministry has not registered a lien or writ at all, the issue becomes more problematic. That's interesting, isn't it? The only remedy to this situation would be to have your members send a facsimile transmission to the insolvency unit. In the facts, they would indicate that they were preparing to seize assets on behalf of a landlord or secured creditor, provide the name of the landlord or creditor, and the name, legal, and trade, and address of the tenant. Then, in approximately 3 days, okay, this is the instructions you've got to render distress immediately. Then, in approximately 3 days, they should conduct another PPSA search to determine whether or not the ministry has registered a lien. The filing of the PPSA lien by the ministry would not interfere with any of your client's rights and or remedies. Where is this leading, ladies and gentlemen? I'm confirming that the Section 22 deemed trust will only be asserted to the extent of the net proceeds of sale after reasonable costs and expenses are deducted. Good luck. What happens if you render your distress for $1,200, okay, and you owe the Ministry of Finance $5,000? Your distress money goes to the government. Okay, so my whole point to you is, I think that the Ontario government, at least in my humble estimation, has wiped out distress. Okay? And I want you to be aware of that. If I can leave you with that today, if your client calls you up and you're acting for a landlord or a bailiff, all right, and they say send in the bailiff immediately, make sure that you get your certificate from the Ministry of Finance. Okay? Thank you.
Harvey, has anything happened since this May 11th letter? Are the bailiffs doing anything?
What happened is the first time the bailiffs contacted the Ministry of Finance, Ariella, and they received a kind of wishy-washy letter. And I said to them, don't do anything until you get something in writing. They did get this in writing, and I'm not aware of anything further at all on this. So again, there's a huge caution in regard to giving instructions to render distress. Okay?
Are there any other questions? Yes, sir.
You mean for other taxes? No, I'm not aware of any personal liability. This is the only act that I'm aware of where the landlord or agent is personally liable.
Harvey, can you repeat the question,
yes.
because we're being
Does
videotaped
this legislation
as well.
impact any other act? Yes, you're right. I think there's a tobacco act. I think there's a tobacco act. Right. But I'm not aware of any other legislation other than the Tobacco Act and the Retail Sales Tax Act. On a personal liability? Okay, okay, that would be interesting. Yes? Yes, of course.
Okay,
If
let's
you
just
get,
repeat the question.
The question is, if you get the Ministry of Ontario clearance, can you proceed with your distress? Of course. The difficulty that you've got is time. All right? Usually what happens is the landlords worry about a tenant that's skulking out, you know, and he says, look, get in there quickly, make your distress. I'm really worried about this tenant owing me the rent. And the difficulty, of course, is you can't. You need your Ministry of Ontario certificate about the PST clearance, and here they're telling you, you make one search, then you make another search, 3 days later, 6 days later, you may have lost the whole deal. The question is, normally you can get a tax clearance certificate in a day or two. I'll tell you, I've had a couple of people call the ministry with regard to this type of clearance. They have not been very successful.
Sorry, Devon's got a question. Devon?
I'll repeat that for the record. A member of the audience has indicated that it's taken 4 to 6 weeks to get that clearance. Okay, so that's really your problem. Yes, you can get it if you wait the 4 to 6 weeks. I would suggest that under those circumstances, what the landlord does is watch its rent very carefully. Yes? Would you go in and take possession of the property without distraining first?
No.
Okay.
Don't. No, holding on to the goods before you're selling the goods.
I wouldn't do it. I wouldn't do it.
Okay.
Okay?
Thank you. Yes, thanks very much, Harvey. Our next speaker is Lisa Borsook from Weir and Fools, and Lisa is going to address us on progress in the courts, the rights of the mortgagee in possession. Thank you.
I guess Harvey's put you all on notice about landlords' rights and respective distraint, and progress in the courts is an interesting way to describe it. The situation for mortgagees is not much improved. We have what can only be described as a surprising, if not disastrous, case for mortgagees who take possession of property and discover that their tenants are not subject to long-term tenancies, which is what they thought. In fact, they're subject to year-to-year tenancies. And that's the Goodyear case, which is referred to in the paper that I've given to you. I'm going to start by saying that I've always distinguished myself as a commercial leasing lawyer and not a real property lawyer. And I really have to tell you that after whatever it's been, 18 years of practice, I'm not sure I know much of anything about real property law anymore. And the problem is that the Goodyear case brings together the two areas of practice. And much to the surprise of the commercial leasing bar, I think, in my view, real property principles, if you will, kind of prevailed. You've got two possible scenarios in the context of a mortgagee taking possession of property. One is a lease that precedes the mortgage, and one is a mortgage that precedes the lease. That seems pretty simple, right? It gets a little more complicated after that. And I'm going to try and reduce this discussion to its simplest terms because I have such a limited period of time. I'm not going to discuss any issues arising from special mortgage provisions, assignment of rent clauses, and the like. I'm not going to talk about the impact of the failure of a tenant to register a notice of lease and how that might affect a mortgagee's rights. Let's presume, for the sake of this discussion, that everybody's done everything right. That is, the landlord and the tenant have entered into what they think are binding contractual obligations. In the case of the tenant, that would be a binding lease with the landlord, and then the tenant went and it registered its notice of lease to give notice to all the appropriate parties, and that the landlord and the mortgagee entered into a binding mortgage which was registered on a timely basis. When the lease precedes the mortgage, then the mortgagee, if the landlord goes into default, takes possession subject to the terms of the lease. That's the simple scenario. It's the easiest to describe, it's the easiest to figure out what's going to happen. The lease may purport to impact on the rights of the mortgagee. It may contemplate that the tenant will attorn to the mortgagee. It may contemplate that the tenant will enter into a non-disturbance agreement with the mortgagee. But if none of those things happen, those terms state the contractual relationship between the landlord and the tenant, not between the tenant and the mortgagee. So those contractual terms will only affect the mortgagee if the mortgagee actually took an assignment of the lease. Will a mortgagee take an assignment of the lease? Never. Not in a million years will it ever take an assignment of the lease. Why? Because then the mortgagee will be subject to all of the landlord's obligations under the lease. That is, the obligation to repair the roof, the obligation to whatever, carry out all the usual maintenance obligations. Mortgagees don't want to do that. They just want to collect the rents if the landlord goes into default. They just want to realize on the proceeds of the sale of the property. They just want to get their money back. So they're never going to take an assignment of the lease. If the lease precedes the mortgage, then the usual rule is that the mortgagee going into possession takes subject to the terms of the lease, and he's stuck with whatever those terms may be. Let's go to the second situation, the more usual situation, in fact, when the lease follows the mortgage, okay? Ordinarily, when the lease follows the mortgage, the lease will stipulate that the tenant will be subordinate to the rights of the mortgagee, which it is per se, and will enter into a non-disturbance agreement with the mortgagee to give effect to that subordination. What's a non-disturbance agreement? As a commercial leasing lawyer, when you act for a tenant, your obligation is not just to negotiate the terms of the lease and get it signed. You have to do more than that. You have to do, in the ordinary course, a sub-search of the title of the property because your tenant doesn't want a full search. You have to register a notice of lease, and if there are mortgages on title, then you should get non-disturbance agreements. Why? Because the non-disturbance agreements carries into effect what I think the parties usually think is their relationship, which is that the tenant thinks it's committed to a 10-year term. The mortgagee recognizes that so long as the tenant is not in default, it will honor the tenant's right to stay in possession of the premises for a 10-year term. And the mortgagee agrees, without assuming the landlord's obligations, that that will be the relationship between the parties. So in the ordinary course, where a tenant has just entered into a lease, is pleased to stay in possession for 10 years. Your job as a tenant's lawyer is to register the notice of lease, if that's permitted by the terms of the lease, and then to get a non-disturbance agreement from each of the mortgagees to assure the continuance of that possession. And the mortgagees are happy to give them. They have their own forms. They're not as perfect as you'd like them to be, but they're fine, and you should usually get them and sign them. In the Goodyear case, we have a different situation. We have a situation where the mortgage was registered first, the lease followed the mortgage, but there was no non-disturbance agreement. The mortgagee went into possession, collected the rents, and ultimately, it was determined not that, much to the mortgagee, well, actually the mortgagee foreclosed the property. The case gets a little complicated. I'm trying to keep it simple. But let's say that the mortgagee subsequently discovered during the process of litigation that it had not a 20-year term with this tenant, which was prescribed by the original lease between the tenant and the landlord, but in fact the tenancy was on a year-to-year basis. Okay, so that was like a revelation, astonishing. When the mortgagee gave the mortgage monies, believe me, it thought that it was doing so in reliance on long-term tenancies. The Goodyear case says no, what you've got is a year-to-year tenancy in the absence of some other contractual or implied agreement between the mortgagee and the tenant. I'm out of time. It goes on and on. Then there's Sadie Moranis.
Lisa, can I just ask you a question? You said that mortgagees are happy to give non-disturbance agreements. That's not always been my experience, and in particular, when you're acting for a tenant that's, let's say, 2,500 square foot, so they don't have huge bargaining power, they're inevitably in a situation where you have to advise them that they don't have that kind of protection because they don't have a non-disturbance agreement, and landlords always want to tell you that they're going to use reasonable efforts to get it. How do you deal with that situation?
Well, it's a difficult situation. The reason that a mortgagee doesn't want to give a non-disturbance agreement to a small tenancy is because when it goes into possession, it kind of preserves the right to say, you know what, this tenancy isn't earning me enough money. The rest of the floor is vacant. I think what I want to do is get rid of this guy and put in somebody who'll take the whole floor at an increased rent. And so a landlord, not being sure that its mortgagee will give the non-disturbance agreement in those kinds of circumstances, will covenant only to use reasonable efforts, or in some circumstances commercially reasonable, commercial best efforts to get the non-disturbance agreement. Ultimately, if the mortgagee doesn't want to give the non-disturbance agreement and you've signed a lease that doesn't mandate its delivery and that requires subordination and internment, the best you can do is tell your client, the tenant, that it doesn't have the security of tenure, that it thinks it has, unless it's satisfied that the landlord has the wherewithal to meet its mortgage obligations. So at the end of the day, there's a risk that's being assumed by the tenant that you can only resolve in favor of a very financially sound landlord. Then you say, well, that risk isn't too significant.
Yeah. Harvey.
For the record, you should indicate, Lisa, that application has been made to the Supreme Court of Canada to appeal the Goodyear case.
By Weir and Fools. That's why I was told not to say anything disparaging about the conduct of anybody in the case.
Do we have any other questions? Nat?
I'd like to say that we have a retail client that does almost 2,000 stores across Canada, and they make it a condition of everything they enter into, whether it's for 200 square feet or 2,500 square feet, that they get a non-disturbance agreement. They find that they deal directly with the mortgagee, they go right past the landlord, and they're able to get a non-disturbance agreement from almost all of them, and it's a rare exception that they don't get a.
It's true. Most commercial tenants that have multiple locations, particularly American commercial tenants, will make it a condition of the validity of the lease that they get a non-disturbance agreement. And the Goodyear case, I guess it could work both ways. In the Goodyear case, it was actually the tenant that brought the application on the basis that the lease was not for the full balance of the term, that it was only a year-to-year tenancy. So it could work in, hindsight's always 20/20. Well, actually, that was...
Sorry, Lisa, can you repeat the question?
The position of the tenant vis-a-vis a new owner of the property who purchases under a power of sale. I don't think the case is any different. The new owner again, is taking title on the basis that, subject to an implied or explicit agreement with the tenant, that the tenant is just a year-to-year tenant. In fact, that's what occurred in, I think it was the Sadie Moranis case, where there was a sale under power of sale. And in that case, not only did the courts find for a year-to-year tenancy, but the terms of the tenancy are usually the usual basic contractual terms that had been agreed to between the original landlord and the tenant, but excising the special terms, if you will. So in Sadie Moranis, the tenant was trying to enforce a first right of refusal to purchase the property, and the court said, sorry, that's a collateral term. That's not an essential term of your year-to-year tenancy, and they didn't enforce it vis-a-vis a subsequent purchaser of the property.
I think there was one more question. That's all we have time for.
May I suggest that from the point of view of the mortgagee, if the mortgagee has an assignment of rents, a general assignment of rents registered on title as part of its security documents, they can then elect their remedy. If they want to exercise the assignment of rents, they can give a notice to that effect to the tenant. If the tenant pays pursuant to an assignment of rents, then there is privy estate created because of the assignment. If the tenant says we're not going to or wants out, the mortgagee may then elect to evict the tenant because the mortgagee may not want to be left with a month-to-month or year-to-year tenancy relationship. There may be some benefit to the mortgagee to try to get an assignment of rents from its mortgagor right at the beginning.
There's, I mean, I think the Goodyear case is specific to a mortgagee who's going into possession. And so there is an opportunity there for real estate lawyers to look at real estate issues and determine what their best bet is in terms of securing performance of the obligations under the
I
mortgage.
actually think that in the Goodyear case, there was an
There
assignment
was an
of
assignment
rents.
of rents, but it was the act of their going into possession
Yeah.
that killed the term of the lease. It wasn't,
Yeah.
the tenant in fact did pay the rent to the mortgagee in the Goodyear case pursuant to an assignment of rents. But the fact that the mortgagee had gone into possession was pivotal in the court's determination of whether or not it was a long-term tenancy or a year-to-year tenancy.
Thanks, Lisa. Our next speaker is Chris Pinnington of Fraser Milner, and Chris is going to speak about the intermarriage of use and exclusive clauses.
Each of use and exclusive clauses has been the subject of recent seminars and papers, and I'm going to try and avoid going over old ground, but unlike the last two speakers, there's relatively little that is new in the case law dealing with use and exclusive clauses. So some of this may sound repetitious, and I apologize in advance. But the focus of my comments is not on use and exclusive clauses per se, but the ways in which they are intermarried or interdependent. We all recognize that use and exclusive clauses are fundamental in a shopping center lease. They are how a landlord and its tenants collectively define in legal terms what the cases describe as their community of interest in the shopping center, and in the words of one judge, its internal non-competitive aspect. The landlord obviously seeks to control its tenants' mix of goods and services through use clauses, and tenants seek to limit competition from other tenants with exclusive clauses. However, both landlord and tenant must strike a balance between too much and too little in the control each exerts. This is particularly important because a successful shopping center cannot be static. As we all recognize, the shopping center industry is constantly evolving and adapting to changing consumer expectations and requirements. A good current example is the rapid growth of the retail entertainment concept, which has introduced new uses into the shopping center, the scope of which might not have been anticipated 10 or 15 years ago. The emergence of e-commerce is another challenge. The way in which a landlord and its tenants collectively adjust to these changes is greatly affected by the pattern of use and exclusive clauses which they collectively put in place. A landlord which cannot restrict its tenants' uses runs the risk of losing control of its shopping center and its long-term value. But a tenant which is unduly restricted in its use may lose the necessary flexibility to adapt to changing circumstances. which puts the tenant at risk, but is also clearly detrimental to the landlord as the tenant becomes increasingly unable to carry on business and pay rent. Conversely, a tenant which has no protection through an exclusive clause is exposed to the possibility of damaging competition. But a landlord, which is constrained by numerous and onerous exclusive clauses, may be unable to attract new tenants or uses, which is in the first instance detrimental to the landlord, but is also obviously not in the tenant's collective interest if the shopping center becomes obsolete. So the landlord and its tenants clearly have a mutual interest in the regime of use and exclusive clauses in the shopping center. The intermarriage is further illustrated by the fact that as a landlord and tenant negotiate a shopping center lease, they must both consider both existing and potential future use and exclusive clauses. For its part, the landlord must rationalize the new tenant's proposed use with existing uses in the center, and more importantly, ensure that there's no conflict with existing exclusives. And the tenant, on the other hand, must understand the existing mix of uses and the limitations imposed on it by existing exclusive clauses. On the other hand, the tenant will want protection from competing uses through an exclusive, and the landlord, in dealing with that request, must harmonize the scope of what the tenant is asking for with existing use clauses in the center, and moreover, the landlord must anticipate future uses which may be desirable and ensure that there's sufficient flexibility under the new tenant's exclusive clause to accommodate those future desirable uses. The clauses are further interconnected in that typically the protection against competition which a landlord will offer should be conditional on the tenant's compliance with its use clause and its active carrying on of the permitted use. All of the foregoing highlights the need for care in drafting these clauses. Precision and clarity is of paramount importance as the cases on these clauses make clear. Ambiguity in drafting or inattention to existing use or exclusive clauses can lead to drastic consequences, including claims for damages and permanent injunctions against either a landlord or a tenant, and in the worst case, termination of the lease, not to mention the possibility of a negligence claim against a careless lawyer. The intermarriage of use and exclusive clauses is reflected in the community of interest doctrine, which I alluded to a moment ago, and several of the relevant cases are referred to in my paper. I'm just going to refer to one, which was the leading case of Spike and Rock, a 1979 decision of the PEI Supreme Court, but it's been subsequently followed in the majority of Canadian provinces, actually. In that case, leases in a shopping center to each of two tenants contained both a clause restricting the tenant's use and an exclusive clause. And one tenant in that case was granted an injunction restraining the breach of its exclusive by the other tenant. In that case, neither of the leases was registered, but notwithstanding, the trial judge concluded that the notice of what was in the offending tenant's own lease was constructive notice of what he might expect to find in another lease of the same nature. Just as an aside, that it frankly leaves me with some doubt as to the extent to which the offending tenant could have relied on a subsearch of title to determine whether there were any registered exclusives, and I'll say more about registration in a moment. And the court in that case held that there was a common link of consideration, and that notwithstanding there was no direct privity of contract as between the two tenants, the clear intent, I'm quoting from the case, of each lease was such that it created a community of interest as between tenants of parallel business operations, and in consequence, an indirect privity of contract, giving each a direct interest in the carrying out of the terms of the lease by the other. The community of interest cases demonstrate the intermarriage of use and exclusive clauses, and they lead to the following general observations by way of conclusion. Some of these should be self-evident and simply confirm good commercial leasing practice in any event. Firstly, a tenant's lawyer should search title for existing exclusive clauses and seek independent assurance from the landlord as to existing exclusives. I think a prudent lawyer acting for a tenant should also independently undertake due diligence of the tenant as to the tenant's knowledge of the existing use and exclusive clause regime in the shopping center, and as to the tenant's immediate requirements and need for future flexibility, both in its use and, if it's applicable, the exclusive clause. A tenant,
It's okay.
30 seconds. A tenant's lawyer should ensure that notice of an exclusive clause is registered on title to all of the lands that are affected by it, and of course it should be drafted so that it's binding on the landlord's successors and assigns. A landlord's lawyer has to understand the existing regime of use and exclusive clauses in the center in order to confirm that the proposed use of a tenant and its exclusive won't violate rights of other tenants or unduly restrict future flexibility. And lastly, a landlord's lawyer should always seek to ensure that the tenant covenants in the lease to be bound and comply with existing exclusives and future exclusives of which the tenant has notice, subject to the obvious negotiation that will take place on that point. It's prudent to have the existing exclusive recited verbatim in the lease and then have the tenant fixed with knowledge and bind it to compliance. Thank you very much.
So bottom line, should landlords avoid exclusive clauses?
I think that the competitive dynamic of the marketplace is such that I can answer that question by saying even if theoretically they should, they can't. I don't think.
You're a lawyer. You're being practical. Yeah.
Well, I mean, that is the reality. I mean, that's the interesting thing about this topic is I think it's a real challenge for lawyers and their drafting skills to be able to accommodate that flexibility and the overlap, actually, which we all
Right.
see in the patchwork of use and exclusive clauses in any shopping center.
Any questions? Great. Thanks so much, Chris. Our next speaker is Natalie Vukovich of Daou, Vukovich, Baker, Siegel, and Banca, and Natalie will speak on revisiting risk and insurance leasing issues.
Hi there. I'm an allergy sufferer. I brought some Kleenex. For many of those who practice in this area of law, the insurance, indemnity, and release provisions of a commercial lease represent the Rubik's Cube of leasing. The overwhelming sense that one gets after fully analyzing the complex provisions of release, insurance, and indemnity is usually something like it would feel to put your brain into a Cuisinart at high speed. Why is this so? Shouldn't it be a simple matter of intertwining logic and law? If only it were that simple. Lawyers writing commercial leases are assisting their client in its risk management function. A risk manager has three basic responsibilities. First, to transfer risk to other parties by contractual lease terms. Two, to place insurance for risk that cannot be transferred. Three, to prevent loss through safety programs. The more the client's risk that is transferred to other parties, theoretically the less insurance the client has to buy, or the less expensive the coverage will be. I say theoretically because contractually shifting risk doesn't always work. Parties accepting risk under a contract or lease may not be in a position to ante up when the time comes, whether out of their own pockets or under the insurance that they were obliged to obtain. And also, courts can be fairly creative when interpreting risk allocation provisions if their sense of fairness is offended. The Supreme Court of Canada and many lower courts have held that a tenant negligently causing damage to the landlord's property need not compensate the landlord or its insurer where the landlord's insurance is available to cover the loss. This flows from the fact that under a net lease, the landlord agrees to place insurance and the tenant agrees to contribute to the cost of that insurance. There wouldn't be a benefit to the tenant from the landlord's covenant to insure if the insurance didn't step in to protect the tenant who paid for the insurance. Now, lawyers for landlords have all but done cartwheels in redrafting leases to avoid this result, and tenants have likewise attempted to resist accepting risk that they perceive they're legally exempt from. So let's go through some basic building blocks first. The three tools of a commercial lease addressing risk allocation are 1, releases, 2, indemnities, 3, covenants to insure. The landlord's theory under the lease is that operating costs for the property are reduced when claims against the liability policy of the landlord are minimized. The entire group of tenants in the building paying the cost of the landlord's insurance program benefits from higher deductibles, lower rates, and higher upper limits that the landlord can achieve by first being released by all of its tenants for any damage caused by the landlord, even if resulting from the landlord's negligence. Secondly, the landlord also theorizes that it's efficient to avoid court disputes over liability for damages and fault, so the tenant should protect and hold harmless or indemnify the landlord from any losses, costs, claims, damages, or liability whatsoever arising from any occurrence on or at the leased premises or resulting from the tenant's use or occupation of the leased premises or the shopping center building. Lastly, to buttress this shifting of risk to the tenant, the landlord wishes to ensure that the tenant will have adequate insurance to respond in the event a claim is made. This thinking is reflected in the landlord's typical set of provisions that are found in my written materials. Now, the tenant's theory is far less elaborate. It goes like this. I pay for the landlord's insurance program. I should get full benefit for that coverage. Now, some parties reconcile these competing points of view with one of these two arrangements. Either each party releases the other for any damage, however caused, even if by the other's negligence, within their assigned geographic area. So for the tenant, within the leased premises, and for the landlord, everything outside of the leased premises. And correspondingly, each party agrees to indemnify the other with respect to any claims brought by third parties on the basis of the location of origin of the claim. For instance, a slip and fall in the leased premises, even though resulting from the water leak from the roof repair that was negligently not made by the landlord, the tenant will assume that liability because it was an event that occurred within the premises. Conversely, a slip and fall in the common area outside of the leased premises that may have resulted from the tenant leaving the banana peel there will still cause the landlord to assume the liability because it's outside of the leased premises. Or another variation that sometimes works, this is the second version, is each party releases the other for any claims to the extent that they have or are required under the lease to have insurance coverage, whichever is the greater. And for this purpose, deductibles and self-insured amounts are deemed to be insured. Now, with respect to liability of third parties, often in this arrangement, each one will agree to accept liability to the extent of their fault, so they can buttress it with their negligence liability insurance. I find both of these arrangements have some appeal. However, I have encountered clients who don't like either, who don't know what to think and want me to decide, and everywhere in between. Now, beyond the basic building blocks of release, indemnity, and insurance clauses, when focusing on risk allocation issues in settling a lease, there is more that has to hang together. First of all, of course, the insurance release and indemnity clauses, and watch out because often they are not just found in one article, but they're sprinkled throughout the lease. Secondly, the repair provisions. They're often within one article, but sometimes they're sprinkled throughout the lease too, especially where structure and HVAC are concerned. And thirdly, the damage and destruction clauses. They're usually in one article, and that sometimes helps. Now, your mission, should you choose to accept it, is to make these pieces of the jigsaw puzzle fit. Here's one specific example. Watch out for preterm construction obligations in the nature of landlord inducements, such as a turnkey, that will create property that should be insured, repaired, and replaced in the case of a fire by the tenant. But the fire clause, or damage and destruction clause, may say the landlord will repair to the extent of the landlord's work. That'll have to be fiddled with to make it make sense. Lastly, and quickly, here's some tips to negotiating these clauses of a lease. 1, if negligence is intended to be released, state so clearly. 2, resist the temptation to begin every release and indemnity provision with the phrase, notwithstanding anything to the contrary. One of them has to be subject to another one, otherwise you've created an endless circle. 3, check fairness at the door. Think commercially reasonable, adequate risk management at reasonable cost, and reasonable administrative burden. 4, if parties are to be benefited by exculpatory provisions, such as the tenant's licensee or lender, or the landlord's property manager or mortgagee, add terminology to the effect that the landlord or tenant is acting as agent for the benefit of the third party to the extent of the exculpatory provisions, or else the third party won't get the benefit of the release since it's not a party to the contract. 5thly, lower your expectations of the administrators. Don't be surprised to hear the tenant state that it can't send, I'm almost done, a certificate of insurance out automatically once a year, that it can only commit to responding to a request to send one. And don't be surprised if you ask to see the landlord's standard form of insurance certificate referenced in the lease to find out that there really isn't such a thing. And in your lease negotiations, last point, go slowly, think out loud, learn to say, let me think about that instead of no or yes. And then when you think about it out loud. The other side will usually help you along.
That's good advice with respect to every clause, I think. Do we have any questions? Yes, sir.
Natalie, we got advice from our consultant that we had to go review our insurance policy to make sure that we were allowed to give express prior releases. Otherwise, if we gave a release contractually, it might not be enforceable against the insurer.
Yeah, that's the case.
Can you just repeat the question, please?
The question is, if you agree to give a release under a lease, then you should check with your insurer to see that the insurance permits you to give that prior release. Otherwise, while you may have released the other party, you won't have insurance to call upon because your insurance policy won't permit you to have given that prior release and pursue recovery under the policy.
Any other questions? We all understand it perfectly, yes. Thank you. Someone once said if someone would write a book on insurance for dummies, it would be a bestseller. Our next speaker is Debbie Rogers of Weir and Fools, and Debbie will speak on the duty to act reasonably and in good faith and its implication on lease negotiations.
Thanks, Ariella. Good morning, everybody. Well, I'm going to speak about the Martel building decision, which is at tab 5 of your materials, subtitled The Negotiation from Hell. Everybody in this room has, been involved in one of these cases, or unfortunately probably more at some time of your practice. And this is just a great decision for talking about whether there's a duty to negotiate in good faith and what the implications are of the law surrounding negligence to this area of law. I've given you unreported decisions in your material. For those of you who like to have the reported site, let me tell you it's 129 FTR 249 for the trial decision. And for the Federal Court of Appeal, it's 1998 163 DLR 4th at page 504. Now, the case considers whether there's a distinct tort of failure to negotiate in good faith and whether there is liability for negligent negotiations. Let me tell you the facts of the case, as painful as they are. The case, the setting is Ottawa. The landlord has a building, one building in Ottawa, almost fully occupied by a federal government tenant, the Atomic Energy Control Board. The tenant is there under a 10-year lease. There's an option. That couldn't be.
No, it's not over.
It's a great case. Bye, everyone. Anyway, it's a 10-year lease with an option to renew. Because of the value, the obvious value of this lease to the landlord 2 years prior to the expiry of the lease starts to negotiate for renewal. The negotiators for the tenant is Public Works, and 2 negotiators from Public Works come out to meet the landlord to talk about what will happen during the renewal term. The landlord, being proficient, brings with him retrofit plans and shows the tenant what he intends to do with the building during the renewal period, and that's when things start to fall apart. For the next 2 years, the landlord chases the tenant to try to get the tenant desperately to respond to him to talk about renewal of the lease. The tenant, the negotiators for the tenant, basically sit on the thing, tell their principals that yes, they're negotiating, they're waiting for the landlord to come back to them. None of that is happening. They're just sitting on the thing, and frankly, almost 2 years go by with the landlord chasing the tenant. The negotiators fail to tell the landlord that there is a non-negotiable bottom line below which they're going to go to tender for the space for these offices. They fail to tell the landlord that there's an actual need for retrofit plans for the building. The landlord is never apprised of that. They fail to tell the landlord that there is a drop-dead date after which they'll go to a tender. So the landlord is in the dark. He's just chasing the tenant. 2 years go by, and finally the thing ends up with the actual decision makers for this tenant. Another thing that the landlord didn't know, which was that there's layers and layers above the negotiators to get this thing approved by the government. It ends up with the decision-making body, and the negotiators provide the decision-making body with incorrect information about the landlord's proposal, misinformation about the condition of the building, and at the last moment, the decision-making body asks the landlord to provide retrofit plans for the building on 3 hours' notice, which you can appreciate the landlord wasn't in a position to provide. So at the end of the day, the landlord loses the ability to negotiate a renewal, and the thing goes to tender. The landlord, I guess, to add insult to injury, decides to participate in the tender and does so. And although when the bids are open, it appears that the landlord has won the bid and is the lowest bidder, the landlord loses. And he loses to the second runner-up, Standard Life, and the tenant goes to the Standard Life building. When the bids are analyzed, what it turns out happened were 2 things. One, the tender bid requested contiguous space for the tenant. The tenant really didn't need contiguous space. It was a precedent, and the person who put the tender out didn't stroke out the contiguous need in the precedent. Standard Life, for whatever reason, knew or didn't respond to the contiguous requirement, and that element of the tender wasn't addressed by Standard Life, but it added millions to the offer by the landlord in question because he had to move the tenant around to meet that need. Secondly, the landlord had no idea that the tenant wanted a renovation plan for its premises because they had just renovated 2 years prior to that. So the tenant had ascribed mucho doleros to renovating the premises that were not ascribed to the Standard Life tender. So the landlord was the loser and brought this action for damages. At trial, Madam Justice Reid said that in Canada at the present time there is no distinct tort for failure to negotiate in good faith. But feeling badly, I guess, for the landlord, said that she was going to determine the case on general negligence principles. She looked at whether our typical tests for negligence. Was there a duty of care? She said yes. She said, was there a breach of that duty of care? She said yes. But then on the third prong of the test, which was the damage caused by the negligent negotiations, she did not see a causal link between the two. And the test that she used was the negligent conduct the cause of the loss of the renewal? And to that she answered, not necessarily, the market was in a tailspin. And so the landlord lost. The landlord then appealed to the Court of Appeal, and the Court of Appeal agreed with Madam Justice Reid that in Canada there is not yet a separate tort. Can I take 1 minute? For failure to negotiate in good faith. But then the court did turn to look at negligence principles and said, was there a duty of care? And the court said, yes, there's a sufficiently close relationship that it should have been in the reasonable contemplation of the parties that carelessness on a part of one party would damage the other. And here, dominant player in the marketplace, the only tenant virtually in the building, long-standing landlord and tenant relationship, yes, there was a duty of care. Secondly, was there a breach of that duty of care? For all the reasons I've told you, yes. Didn't set a proper schedule with the landlord to give him realistic deadlines. Didn't tell the landlord who had authority to commit the tenant. Didn't tell the landlord retrofit plans were going to be needed, and all of the other offending things that I've told you about previously. But where the court differed is on the test of causation. The court said that the negligent negotiations were, if not the only cause, the main cause for the damage that resulted to the tenant. And the court found in favor of the landlord and sent the case back for determination of damages to Madam Justice Reid. Since then, though, the tenant has appealed the case to the Supreme Court of Canada, and leave to appeal was granted in February of this year, so we all have to wait for the result. But what we're left with, which is very important, is that there is a duty to act fairly to your adversary in negotiations and in the tender process, which is a remarkable result. Only lawyers would think it was remarkable to act fair, that you have to act fairly, but that's where we sit now. And it's interesting that this also applies to the tender process, and with the popularity of RFPs right now, people should really be aware of this case.
So, some of us have interpreted that case as being a duty to act reasonably is sort of implied. And when you draft clauses that say the landlord may arbitrarily withhold in his sole discretion its approval, et cetera, do you think that that takes it out of the realm of that? You've contracted out of the duty to be reasonable?
I think that, I'm not sure of the answer to that. I think that if that is what is put forward, my own gut reaction in thinking about it for 2 seconds is if you put that out and it's out there to be negotiated by the tenant, I think that would be up for argument. I don't think it necessarily takes away from contractual provisions that were pre-negotiated. What's really going on in this case was something where one party is left in the dark, right, at the mercy, at the mercy of the other party. And the case, Madam Justice Reid in her decision specifically says that this doesn't mean that you have to act in the interest of the other party. No. You just have to be fair.
We have time for one question.
Anybody have a question? Yes.
Would this also apply, for instance, if a tenant was negotiating in good faith on a lease renewal, but it hadn't been finalized prior to the notice date, that the court might overlook the fact that it hadn't been firmly reading the renewal exercised by the notice date?
The question, I think the question you're asking is if the tenant, in exercising its right to renew a lease under its lease, fails to give notice within the required period of time, would the court look to the reasonable aspect? Which is probably outside of
Yeah.
your topic, although it's been my experience that all the cases come down pretty hard and fast on that one, that you really have to strictly comply with the notice provisions.
Yeah. Yeah, I would
Thanks.
agree with that.
Thanks, Dave. Our next speaker is Celia Hitch of O&Y Properties, and Celia will speak to us on tips on negotiation of rights of first refusal, rights to expand, first opportunities to lease, and options to purchase.
6 minutes. 4 topics. I think it's safe to assume that I'm going to refer you to my paper, which is at tab 6. It's been arranged what is in my experience the order of how what you're most likely to encounter through to what you're least likely to encounter. So you'll find it starts with rights of first offer and ends at options to purchase. It's practical in its orientation. I hate doing case research. So if you want an academic treatment of rights of first refusal and options to expand, I would refer you to a paper that was written a couple of years ago for the original 6-minute commercial leasing lawyer by Deborah Watkins, which does a really good treatment of that. You'll see if you look at it that it's written in a checklist form. So some of the items repeat over because the topic is, the thought is important to more than one type of right. I wasn't trying to bore you to death, I was just trying to segregate it according to the topic. It's typical that these particular rights are more likely to show up in an office than in a retail lease. Retail tenancies don't tend to have things like options to expand. Office tenants often do, so you're going to find them focusing most on office buildings right now. I went through it and I picked out 6 common themes or sort of thoughts that I want to highlight. Hopefully I'll get through all 6 before the egg timer goes. The first one is that for all of the rights, and I think this is pretty self-evident, but I think it's worth repeating, you need to be certain as to exactly what it is that you're talking about. That's a drafting issue. You also have to bring some foresight to how you're drafting it. But the nuance that I would point out that most often comes up when you see these is somebody will have a right of first offer on space adjacent to the tenant's premises. Well, if the tenant is on the 30th floor, the space adjacent is whatever's adjacent on 30. If not within the context of that right, they simply make a deal with the landlord to take space on 29, and you don't turn your mind to it, have you just given the tenant a right to adjacent space on 29 as well as on 30? I think you probably have. So what I would always recommend is that if you're talking about a certain area of space, put a plan on, outline it in a color, say what you're talking about, because you can accidentally slip your rights into more space than you intend. The second point I would make is that for any kind of expansion right, generally you want all the space to be coterminous so that at the end of the day, if the tenant exercises a right, if they have a 10-year deal and they exercise a right in year 4, you don't want that to be a 10-year deal. From a tenant point of view, you don't want to have 30,000 feet expiring in 1 year and this pocket of 4,000 that goes for 4 more years. Either you're going to be trying to sublet that space or just vacate it and paying rent on it, or you're orphaning some of your employees in that space. From a landlord point of view, you want to make sure that all the space comes to market at the same time or that you're renewing all the space at the same time because you can give it a more thoughtful, more consolidated treatment. The third point I would point out is that along with the other sort of normal preconditions that landlords like to write into rights, there's a subtle importance in this particular one to the tenant being in occupation of their existing premises. A lot of people don't really see that as important on first blush, but if you look at it, a tenant shouldn't really have a right to expand into more space if they're not already using their existing space. From a landlord point of view, if the tenant takes that space, the tenant's probably going to turn around and sublease it because they've probably already sublet their existing space. And so the tenant is now marketing the landlord's space, which from a landlord point of view doesn't make sense. From a tenant point of view, they're probably not going to want to exercise that anyway, but you just don't, it's one of those things you probably don't want to leave open if you can avoid doing it. I need to flip to get to point 4. From a tenant point of view, and I've been a landlord all of my working life, so I plead selective memory loss if anybody ever raises this with me. From a tenant point of view, it's important to consider whether the rights are going to be once only or revolving. Every landlord wants these rights to be once only. My best case scenario is a tenant has a 10-year lease, they have an option to expand or a right of first refusal. In year one, I get to blow that away. I give them that space. I offer it out to them. They moved in yesterday. They don't need more space right now. And what they're going to say is, no, I don't want it. Well, great, because now it's my space and I can do anything I want with it for the rest of their term. From a tenant point of view, if you have a 10-year lease and in year one I try to blow you away, if I do a 5-year deal and that space comes back to market in year 6, how come I'm not talking to you first? So that's my selective amnesia, but I would point that out to you. My fifth point, from a landlord point of view, and this is a very practical issue. I've been working in-house for a very long time, and if you're in a law firm, you may not have the same awareness of this, but there's a really practical issue for landlords, and there's a really solid reason why landlords hate giving these rights. It's because there is no computer software that lets you track them properly, quite frankly. It's done manually in manual reports. We've been looking where I work recently at some of the big accounting software packages, CTI, JD Edwards, stuff like that. Most of them have some kind of leasing adjunct, SSLE, or you can buy ASI and drop it in. The reality is that none of them can really answer the question that I put to all of them. If I have a tenant on the 30th floor with a right to expand on the 31st through the 33rd floor, where do I track that? Can I track it on 31 through 33? The answer is always no, we track it on 30. Well, like, I don't want it on 30 because they're already occupying 30. I need a report that tells me when I take 32 to market, hey, look, you have a tenant on 30 who has an option on this space. So from a landlord point of view, if you're going to give these, it's critical that you have some internal system that puts checks and controls into this. If you breach it, I gotta say it's a breach of the lease. I'm not gonna pretend it isn't. Depending on your drafting, it may be a fundamental breach of the lease. So be really, really careful about the system that's set up before you just hand those things away. My last point, which is actually 2 points, in options to purchase, there's this whole topic about whether or not they renew with renewals. Just say it if you mean it. That's my best advice. But the 2 things I wanted to point out are, if you're writing an option to purchase, think about what's going to trigger it. If you have an intercorporate transfer, an affiliate transfer, if you have 2 partners who are going to, one may buy the other out, I'm almost finished. Think about whether or not that should transfer.
I'm thinking of taking it home for my kids and see if they will listen.
See if they listen to it. In particular, if you have 2 partners, partner A and B, A is really the dominant partner, you like them. This is from a tenant point of view. It may be okay if A buys out B, but if B buys out A, you may not want B to be your landlord. So although they may say, hey, it's really the same thing, you may not think it is the same thing. And my very, very final point, I promise, is consider carefully the problem of multi-property purchases. Portfolio sales are really how real estate is being transferred these days. So if your client has an option to purchase a building, that's great, but what if the landlord takes 25 properties to market? Does it trigger your client's right? Doesn't it? Think about it in advance. That's what I mean about bringing foresight to your drafting. Thank you.
Thanks a lot, Phil. Do we have any questions?
Is it hard?
You mentioned that a breach of the right of first refusal by a landlord might amount to a fundamental breach, and there was a scary case a couple years ago that held it was. What's the drafting tip to get around it? You said depending on your drafting.
Well,
Let's just repeat the question for a moment.
I'm not sure I have the drafting tip, but the question was that I mentioned that a breach of a right of first refusal might be a fundamental breach, and what's the drafting tip to get around it? I'm not sure I really have the answer on that, because actually I don't remember the drafting in the case. Do you remember the drafting?
I do, because
Okay.
I was directly
Okay,
involved in that case, unfortunately. But in that case, there was a first right to expand in the adjoining space. Landlord leased out the adjoining space, not realizing that there was this first right. That new space that was leased out had a right to relocate that tenant, consented the tenant not to be unreasonably withheld. The number 1 tenant whose rent was $30 over market a square foot and happened to be a law firm said, wait a second, fundamental breach. And the court, both at trial and at appeal, unfortunately held that it was a fundamental breach. I personally, I don't think the courts care what my opinion is. I think it's bad law, though. And it'd be interesting to see whether, if the issue ever comes up again, and that was. Well, I was drafting around that in the relocation clauses where that's for sure that the tenant doesn't have the right to consent. There's an absolute right of the landlord to relocate the tenant, so it doesn't become wishy-washy. But in terms of saying, well, it's not a fundamental breach if I don't recognize your right, no.
Yeah, because, I mean, there's sort of the obvious stuff, don't make it a rep or warranty, but if it's a covenant and the court makes that decision, I'm not sure how you draft around it, frankly.
Thanks a lot, Celia. Our next speaker is Jennifer Babe of Miller Thompson, and Jennifer is going to speak on the implications of the new case law and priorities among landlords, tenants, and lenders with respect to fixtures.
Just as a preliminary note, the ministry, the PPSR system, is going down July 1, 2, 3. They're implementing their Y2K program for their upgrades for years, birth dates, registration numbers, vehicle year models. I'm sure the system is, when it comes up, is going to work flawlessly. But as we all know, every time we have a system shut down, they're a little slow in getting themselves back up, particularly after long holiday weekends. If you have stuff coming up, pre-register, get your post-registration searches now, because I think we're probably going to have about a week-long gap in file currency at the beginning of July. So, I guess I'm the only non-real estate lawyer in the room. So I usually come here with the perspective of the lender and the supplier and the lessor trying to get my stuff back from your clients as landlords, mortgagees of landlords. And that comes down to the nitty-gritty of what the heck is a fixture. And you know what? I didn't know 2 years ago, and I know even less now. The Ontario Court of Appeal came up with a great decision in Starkman. And basically, Justice Doherty said, geez, you know, we've got this darn spray paint booth, and it's 28 feet long, and it weighs a couple tons, and it's got plumbing, and it's got wiring, and it's vented through the roof, and it's got all these mechanical contraptions. And you know what? It's a darn close call, but that darn thing's a removable trade fixture. And so he says in his wonderful decision that the legislature has not seen fit to abandon the common law in Ontario and the distinction between fixtures and other goods and chattels. And the legislature has not altered the common law for the definition of fixtures applicable to the law of distraint. So as long as the common law prevails, the manner in which the property is attached to the land will be a significant consideration when deciding whether property is subject to distraint. Because basically he said if it's really, really affixed to the building, well, heck, it's not a fixture anyhow, it's part of the building, you can't distrain on that. And if it's a removable trade fixture, well, gosh, you really cares, you can't distrain on that either. So now, when I'm acting out there, I've got to figure out, well, if it really, really stuck to the building, then, gosh, your lease probably makes those fixtures that are really stuck onto it part of the building. I'd also suggest you take a look at the definition of the word goods in the PPSA. It says it doesn't apply to building materials. So when I get packages in from banks telling me I'm supposed to go out there and enforce on SBL packages, and what did they finance? They financed carpets and paints and HVACs and new wall dividers and all that kind of good stuff. I'm going, well, the banker really didn't think about this because it strikes me that those things are really building materials, and I don't think I've got a security interest over those in the first place. So if it's really part of the land, I probably don't want to forget about it in the first place, and you guys who own the buildings, it's probably yours. But then I get to this darn degree of annexation. And included in the paper is not only the Starkman case, but there's a Newfoundland decision that said, geez, you see this buried gasoline tank for this gas station? That's a chattel. Okay, so now I'm really scratching my head about these darn degrees of annexation. So when I come down to it at the end of the day, and I got to make a business call here, because it's going to be a business call. I don't know what the law is on this, because there is no clarity in our cases now about what is a removable trade fixture, what's part of the land. So, because I really thought something part of the land might indeed be something that was actually buried underneath it, but apparently not in Newfoundland. So, what do? Well, I think what I really need to do is, instead of getting those very simple little landlord waivers, which some of you guys sign and some of you guys don't, and somehow times we negotiate them anyhow, maybe it would behoove us all to sit down and actually think about what's in this particular deal. And if I really want to keep the HVAC and the paint and the stuff because I'm the landlord and I'm financing certain things for leasehold improvements, maybe I want to say so. And if I really need back the specialized chlorine bleaching plant, which is a CIBC decision in here in Lighthouse, maybe I should say so. And maybe we should clarify as between our respective interests what things we expect to get back from one another. And think about that day one, because the courts have given us absolutely no direction in this darn degree of annexation stuff. The only thing I'm doing these days is, oh, is it a fixture? Well, who are you asking me to represent? Quite bluntly, that's my problem. You know, it's which side of the table do you want me to be on? So I would suggest we start thinking about doing these little agreements at the beginnings of the deals for the really important, expensive stuff that we're all concerned about. And maybe we need to tack those little extra paragraphs on landlord waivers. And where does the law go from here, because it really is a mess? Well, the CBAO PPSA committee sent in its submission about a year ago now, and it strongly recommended to the province of Ontario that we need some help here. There is no definition of the word fixture in any of our statutes. There's no definition of the word building material. BC and Alberta tried to do that in their PPSA statutes. It's not great, but it's a start. We've asked for that. Don't hold your breath. We're not getting any new commercial law in Ontario unless it's uncontroversial and tucked into a red tape bill. And the CBAO is got a committee starting up. It's had its first meeting with representatives of the PPSA group and the representatives of real estate group. And if we don't make a submission, what we're at least going to try to do is come up with some practice directives for members of the bar to help us try to figure out things like when you have security over land and personality, how do you do your enforcement steps together, and things like foreclosure, where we have different foreclosure time periods and issues and notices and stuff. And the second issue we want to look at is fixtures, because we haven't got a clue, folks. So if the courts can't really help us and the case law is getting worse or not better, I think we need some little agreements at the beginnings of our files, not at the end when I ask which side you want me to act for.
Thank you. Do we have any questions? Everybody is just as confused as you are. Yes.
Exactly.
Thank you. Our next speaker is Phil Sanford of McCarthy Tatro, and Phil is going to speak about the continuing saga of property tax reform. Where are we today, and where will we be after tomorrow's appeals?
Well, it's basically a mess. Absolutely phenomenal mess. The one thing that we were sure of 5 years ago is the system couldn't get any worse. We're not sure of that now. Half my clients are delighted, half are absolutely unhappy, if I can use a polite word, about it. I have to remember when I'm speaking to people whether I should say Ernie Eves is a genius or Ernie Eves is a fool. Either way, the fundamental difficulty with the reassessment for commercial and industrial properties, they did a pretty good job on residential, but for commercial and industrial, we're getting a divergence between market value and tax, and that divergence has become fairly transparent, which has certainly caused some grief. Let me just touch very quickly on a couple of issues that are of, I think, particular interest. I had a meeting recently with our real estate lawyers, and I was surprised that the level of knowledge was not as high as I would have expected, so some of this may be new to some of you. The 1998 taxes outside Toronto, 98 taxes, are generally not final. There is going to be a rebilling for 98 for commercial, industrial, and multi-res. Virtually every municipality outside Toronto has not rebilled. Now, I think somebody told me that a couple have now rebilled, but the effects of Bill 79, which was dropped on us last November, that's the famous capping scheme outside Toronto, was introduced as an optional capping scheme. Effectively, it was mandatory. That capping scheme, which limited tax increases to 10% plus budget increases for 1998, then 5 more for 99, and 5 more for 2000, the scheme has generally not been implemented by municipal billing. In Mississauga, for example, which is a client of mine, is going to be sending its bills in August, and they're waiting for the phones to ring right after the bills go out. A lot of people understand that the capping is going to be implemented. An astonishing number of people don't understand that people will have to pay for it. So there are a whole bunch of taxpayers right now who have enjoyed the benefits of tax reductions in 98 and 99, who are going to have most of the reductions clawed back. For example, somebody told me last week about a client who had received a fairly nice reduction on a property in Kitchener. Their taxes went down $500,000 in 1998, and they said, gee, this is great. The consultant told them last week, hey, bad news, you're going to have $450,000 of that clawed back. So this will be achieved, and this may be of interest to real estate lawyers, this will be achieved by adjusting the billings for the current owners. Now, my partner said, how can that be? I'm not going to tell you in 6 minutes, but trust me, it will be the current owner who gets the bill. There will be, whether we have reductions being credited or monies being clawed back, there will be some issues between vendors and purchasers, and I would expect that some of you may get phone calls on that. A lot of people are going to be looking at their undertakings to readjust. A lot of people are going to be looking at the tax certificates from the municipalities and saying, gee, I thought these things meant something. The answer is apparently not. Let me touch on a couple of other things quickly. The Assessment Review Board, most of you probably know, has final jurisdiction to hear appeals. It used to be, a long time ago, we had 3 tribunals, then for 10 years 2, we're down to 1. The trend is getting scary out there. The review board has beefed up. They've made an effort to become more professional. I think they're actually doing reasonably well. But people who dabble in the business often don't understand how much the board has changed. It used to be a place where you could literally phone in an adjournment request. It was wonderful. You just called and said, gee, you know, I have to get my hair cut on Tuesday, and can I have an adjournment? And the answer was always, oh, sure, no problem. Well, if you look at the materials with my paper, everything has changed. If you read their guidelines, it looks like it takes a death in the family to get an adjournment. The truth is, it depends upon the chair. Some of the chairs are being tough as hell. Some are still get along, go along. Next one, equity. Section 60 of the old Assessment Act, which essentially said you determine, it doesn't matter whether a property is fairly assessed, the question is whether it's fair in comparison with similar real property. There's a widespread belief that the equity provision no longer exists. It doesn't. It was repealed but reintroduced in a kind of stealthy way in another section of the Act. Long and the short of it is most people think that equity is still there. And oddly enough, the taxpayers are using that because a lot of the values are low. I just did an appeal on an office building where the ministry, the Ontario Property Assessment Corporation, said the market value was $17 million. And indeed, we said, no, gee, the market value is a lot more. You have undervalued us, but you've undervalued comparable properties by a greater degree. And so it's a kind of reverse equity. We say we want the same favorable treatment. Last thing, and then I'll be quiet because I take it I'm out. The future, boy. Mr. Eves perhaps knows, the rumor is that we're going to continue with the very slow phase-in. The rumor is we're going to see 5% increases for 2001, 2002, 2003. And if you do the math on this, if you have a significantly underassessed or overassessed property, it could literally take 100 years to get to where you should be at the current rate.
Thank you very much. You could probably speak all morning on this topic. Are there any questions? Yes.
I'm curious, if you buy a building for $10 million, or
buy it the next day for $7 million, and you go to the board and say, hey, I bought it for $7 million, how can it be assessed for $10 million? I want to break on the price. Do you get it?
Well, the question is, if you, you buy a property and the sale price is a clear indication that the market value the assessors are using is wrong, do you get a break for that? There is a case in the Court of Appeal under the old system called Ness Holdings, and that case says, yes, you do. You get the break. Difficulty with that is that nobody in the system other than the judges in the Court of Appeal believe that that decision is right. So it sounds familiar, doesn't it? So that the net of it is, it's a struggle. Essentially, you really need to show that you need to look at the value of the subject, you need to look at comparables. If you can show that the value is more wrong for your property than the others, you're off to the races. But it's not, let's put it this way, it's not a lay down hand to go in and say, I have a sale. The exception to that is a house or a cottage. On houses and cottages, there's a lot of politics in the decision-making process, and there's a tendency to take the sale prices as the clear indication of value, period.
Thank you. I'm sorry, we're just running late. Our next speaker is Ron Goldenberg, and Ron is going to speak about how to structure listing agreements and commission agreements. Thank you.
Good morning. Because this topic isn't usually covered at leasing seminars, my remarks are going to be a bit more basic than I would otherwise address at an illustrious audience like this. Unlike listing agreements for the sale of a property, where all you have to do is make sure the commission's payable on successful completion only, there are quite a number of things to look at in a leasing listing agreement. In my 6 minutes, I'll try to cover the 6 most important ones. In the materials, I put a copy of the Toronto Real Estate Board MLS listing agreement for your reference. And if you're not using an actual listing agreement, the commission payment clause where the landlord signs to accept an offer usually contains a number of these points. Issue 1, the commission rate. The MLS form expresses the commission as a percentage of rent payable during the first year, the balance of the lease, and renewal periods. The trend in industrial and retail commissions is to still calculate them in this manner as a percentage of rent, but the pretty clear trend in office leasing has been a movement to a flat rate per square foot, so much per foot on a 5-year term, so much per foot on a 10-year term. If you're looking at a listing agreement for a client, you should check with several landlords and several brokers each time, because the going rate seems to change very regularly with market conditions, and what you thought was the going rate a year ago isn't going to be the going rate anymore. If the commission is based on a percentage of rent, it's of course most important to specify whether it's on the net rent or the gross rent, and if it is on gross rent, to be very careful to say what isn't included. Fairly typical office, industrial commission today would be 5% of the first year's gross rent, 2% of subsequent years' gross rent, and 2% of renewal rents, although it is still very rare to pay a commission of any sort on at more than 10 years. If there's a cooperating broker, i.e. not the listing broker involved, the listing broker splits his commission with the cooperating broker, and very often a landlord will agree to pay a higher rate of commission if it is being split and a lower one if it isn't being split. The rates and amounts are definitely negotiable, although sometimes within a fairly narrow range. And interesting point, they don't seem to ever be reduced by rent-free periods or inducements that are given to the tenant. They don't seem to affect the commission calculation. Issue 2, the overhold clause. Generally, the obligation to pay commission is triggered by a lease being entered into during the term of the listing agreement, or within 6 months thereafter, to a party introduced to the property during the currency of the agreement. This is meant to cover a situation where a tenant is introduced to the premises during the term of the agreement and does a deal with the landlord after it's expired, and without an overhold clause, there would be no commission obligation. The 6-month period is the usual one, but generally negotiable. The concept of a party being introduced should be clarified. I find that brokers will claim that anybody who they received a mailing or made a phone call or drove by and looked at the sign is introduced, and if you have the opportunity, you should try to define that as somehow someone who really had an interest in the property. The MLS agreement says the broker must give a written list of overholds before the agreement expires, so you can settle them at that time. Again, you might try to limit this to a certain number of overholds. I've seen recently a broker send out a list of about 200 people to whom he'd sent a mailing and say that it was all of these. There's also a provision that talks about related parties, nominees, and principals, and it's pretty tough to know who you're dealing with after the overhold if it's as broad as that, so there should be some attempt to limit that to named people. The point on the overhold is be aware that there's a clause there and try to deal with it as best you can. By the way, if the property is relisted after the expiry of the agreement with another broker, the amount of commission you pay the new broker reduces the amount you owe over the overhold, and that's a pretty important provision. In preparing for this morning, I looked at about half a dozen of the broker's own agreements, not MLS forms, and I don't know whether I'm surprised or not, but half of them didn't have this provision in it. Issue 3, when is commission payable? The usual possibilities are on the signing of the offer, the signing of the lease, the offer becoming unconditional, the tenant taking occupancy, tenant opening for business, and tenant starting to pay rent. The MLS effectively says it's the earliest of these. Landlords would like to say it's the latest of these. There's no right or wrong answer, but I think what's fair is that an actual lease is signed and the term commences at a minimum. Commissions are usually paid all at once up front, and renewal commissions usually paid when the option's exercised and the renewal term begins. There are some exceptions to that. In the larger deals, they are occasionally paid on a yearly basis each year of the term. And on a pre-leasing situation where a real long period of time goes by between when the deal is signed and when the building's built and occupied, there's often portions paid up front and portions when the lease commences. A related issue is to deal with outstanding commission liabilities when you're buying or selling a rental property to make sure that the commission obligation either stays with the vendor or is properly adjusted between vendor and purchaser, or you might be getting invoices from the agents in when leases are renewed 3 years after you've bought the building. Fourth issue is the term of the listing agreement. Agents and, of course, lawyers generally don't see these things before they're signed. Agents usually fill in a long period. 6 months would be the most common, sometimes even longer. You might consider adding a provision to an exclusive listing to allow you to put the property on MLS at any time to get more exposure if the thing's not being moving. And another approach is an ordinary cancellation clause. I'll rush through the last two. Issue 5, broker's duties. The MLS says that the commission is earned in consideration of your listing, photographing, and agreeing to offer my property for lease. That's not very much. You should specify in there the agents to be working on it, the signs to be put up, the advertising to be done. Anything the broker's told you to get the listing should be incorporated into that agreement. Last point is subleasing. A listing agreement for a sublease is considerably more complicated because you have to deal with the terms of the existing lease for landlord's consent, possible change of use, credit information, etc. And I guess my advice is to deal with those things up front. Think of what you're actually going to need to do the sublease and figure out which of those should be incorporated right into the listing agreement.
Thank you, Ron. Do we have any questions? Okay, I think, sorry, Craig, if you don't mind, I'd like to just break now because we've just run over a little bit, and if we could come back in 10 minutes around 10:45, that would be great. Thank you.